Hello everyone, welcome to Court with Krissy and Linda. We've got an update. This pro se is back. And for the record, if he has to go through another three-peat appearance without having to pay attorney fees, I'm not going to be very happy. We hope you like it. Court with Krissy and Linda is now in session.
Okay, looks like we got all the parties connected. So we'll go on the record in Collin versus Collin, file number 2411622. We have Mr. Vernon present with his client, Ms. Collin. We have Mr. Collin present by video, also Mr. Vernon and his client by video. This is set for a couple different matters here today. We do have this set for a status conference. Mr. Vernon, we've got a motion from you to compel discovery, and then a motion alleging that Mr. Collin has not complied with the prior order of the court. So if we could start first with your motion regarding discovery. I did review your motion. Is there anything you wanted to state for the record in support of that?
All I would add is that discovery still has not been provided. We sent over those requests to produce documents. We've received none. And we obviously would want those documents before we had in any evidentiary hearings. And I know we've rescheduled mediation once, so I certainly would like those documents prior to the mediation.
All right, thank you. Mr. Collin, is there a reason why you haven't provided the documents to Mr. Vernon?
For one, I don't consent. For two, I haven't asked the plaintiff for any type of discovery of her information that they want to disclose up from me. And for three, we are separated, and we were only together for 3 years, and we were on food stamps and government insurance prior to her separation. And I don't have any financial things that even matter to disclose of that would benefit them in any type of way besides my house.
Okay, so it doesn't matter whether you consent or not. If they make a proper request, then you're required to provide that information to them. So that's not a reason. The fact that you haven't requested any information is not a reason. They have a right to request information from you. And your third reason, the status or duration of the marriage also doesn't really have anything to do with discovery. So you haven't stated any legal reason why you shouldn't be required to turn over those documents. So Mr. Vernon, the court will grant your motion to compel. In the order granting the motion, Mr. Vernon should specify that Mr. Collin has 14 days to comply with the order. Mr. Collin, if you fail to comply with the order to compel, then you may be subject to contempt sanctions, including default. So you are required to turn over those documents. Do you have any questions about that?
I don't know what documents he's requiring.
Mr. Vernon, is this the subject of a written request?
Yeah. Yes, Your Honor.
Okay, so you've been provided with a written request, Mr. Collin. You just need to read that and provide the documents that have been.
Well, they're going to have to resend them again because they might have got misplaced.
Mr. Vernon, that's up to you whether or not you want to send a courtesy copy to Mr. Collin. If you've already served those on him, Mr. Collin, that's your problem if you lost them. I'll leave that up to Mr. Vernon if you want to send him a courtesy copy or not.
Seems
Thank
like
you. I think we can probably manage that. Your Honor, I would ask the court, in our motion, we did ask the court to consider costs in this matter as Mr. Collins answers and is without substantial justification. Our appearance here today obviously is costing my client time and money. We would ask the court to consider imposing sanctions as a result for fees as a result of having to be here today to compel that discovery.
Because this is the first motion to compel, and because Mr. Collin is a non-attorney and may not have understood his requirements under the court rule, I'm not going to impose any attorney fees at this time. If he further fails to comply, then the court would consider those at a later date.
Thank you.
The request for the appraisal has already been done as well. I did get that to go through.
Okay, so that's the next question. That's Mr. Vernon, your motion to show cause does relate to that appraisal. Mr. Collin, you're saying that an appraisal has been done, is that correct?
Yes, Your Honor.
Okay, Mr. Vernon?
So, Your Honor, we did receive a copy of that appraisal today or yesterday late. The motion that we filed, I think, still has some bearing and some validity. I think it's pretty clear that Mr. Collin, prior to the filing of our motion, intentionally interfered with the accomplishment of that and essentially caused additional delays. The appraisal is done now, except that Mr. Collin is refusing to share in the expense of that appraisal. The cost is $500, so I would ask the court to order Mr. Collin to pay to my office $250 so that we can pay Mr. Kirsten the amount owed to him.
All right, Mr. Collin, is there any reason why you shouldn't pay half of the appraisal cost here?
Well, for one, once again, I don't consent to any of it, so you guys are going against my wishes. If she wants the appraisal, that's not my fault if she doesn't have the money to do it. I did go forward with making it happen for them, like it was stated it was supposed to do. Nothing was stated that I was supposed to supply any financial support for the situation. And as of the year so far, I've already supplied $6,564 of support to go towards her affair and her attorney, and I guarantee that it hasn't gone towards my children. So
okay. Again, it doesn't require your consent. The law requires that appraisals be done when property has to be split. So it's not something that you have to agree to in order for it to happen. It is pretty standard practice for the parties to split the cost of appraisals. So the court will order that you split the cost of that. And Mr. Vernon will grant your motion to that extent.
how does the law apply when the oath of the marriage is being broken? How does the law still apply in accordance to what makes the law? When you get married, you have to say an oath, which makes the law. How do you not get penalized when there is clearly an affair and negligence going on in a marriage towards one party or the other? How does the law still apply when the oath that makes the law is being tampered with and not followed?
Okay, so Mr. Collin, Michigan is a no-fault divorce state. That means that parties can get divorced without having to prove that the other side was at fault. It also means that although fault can be a factor in how assets are divided, generally assets are divided equally. So that's the law.
It's a sad law for our state, Your Honor.
Well, you can contact your legislator and ask for them to see to change that, but that is the state of the law at this time. So the court will order that you pay half of the appraisal. And Mr. Vernon, if you can put that in your order, I will provide for 30 days for Mr. Collin to remit that payment to your office.
Payment to our office, okay.
And can you provide to him, if it wasn't part of the appraisal, an invoice from the appraiser with the exact amount?
Yep, I have all of that right here, and we will, if we haven't already sent that out, we will get that sent out.
Okay. In terms of proceeding, Mr. Vernon, I'm not sure where things are at in terms of scheduling. Can you tell me what the plaintiff is requesting for scheduling going forward?
So my recollection is that at the last hearing, the court granted our motion to extend the deadline to accomplish mediation because there was evidence and discovery that we had not received. I believe at that time the court ordered that the further hearings were going to be essentially scheduled after mediation. So I don't know that we have any further dates. We're still working on getting a date for mediation. We obviously want the discovery first. So if we can get all of that stuff and then schedule a date for mediation you know, I mean, if we've given him 14 days to comply with the discovery, I think we would need at least 14 days beyond that to accomplish mediation. So if we could have a status conference, that's 30 days. So if somewhere in the 45 to 60 days out, I think we would have made some progress that we can then report to the court.
All right, thank you. Mr. Collin, is there any scheduling that you would like to request in this case?
No, Your Honor.
Okay, so the court will order that mediation is to occur within the next 60 days. The court will set this for another status conference at that 60-day mark. If the parties have been able to reach an agreement through mediation, then we can use that date to take proofs.
I did forget about one thing, Your
Sure.
Honor.
Go ahead.
I filed a complaint about parenting time that the plaintiff had missed, and I received a letter back from the plaintiff and her attorney, but there was nothing showing that we were how we could go forward with me getting my 2 hours back that I missed.
Did you file that complaint with the friend of the court office?
Yeah.
Okay, so they should schedule a hearing for you before the referee on your complaint.
Okay. They did not do that yet, and I received their supposed evidence that Doug Mago and I agreed supposedly, but it has nothing to do with me and Doug Mago. It has to do between the courts and me and the plaintiff. So that is not factual evidence submitted.
All right, I'm just checking. We're going to check right now to see if that hearing's been scheduled yet.
I have it on my calendar for next Wednesday at 9 a.m.
That's for you, Mr. Mertz.
The 12th is the hearing with you. Half day duration as defendant's objection to referee recommendation.
That's a separate one.
I do not. So sometimes those, I mean, if it's filed in front of the court, I don't know if they've done anything with it or not, but I do not have it.
When did you file that complaint, Mr. Collin?
That complaint would have been filed January 9th. Yes, the 9th.
All right. After this hearing, I'm going to check with the friend of the court to see why that hasn't been set for hearing. It should have been set for hearing.
Okay,
now,
thank you.
I think.
Your Honor,
Next Wednesday, our hearing is on the objection to the referee's recommended order. So that's a different matter.
Yes. Yep.
Okay, we're back on the record. I did just check with your case manager. They have the complaint and answer filed. They are going to be getting a date within the next couple of days, and the notice of that hearing will go out. So, Mr. Collin, look for that in the mail, but they will be scheduling a hearing on your complaint here in the next couple of days.
Thank you, Your Honor.
That'll go forward with the referee.
Okay.
Okay, that's all I have for this hearing today. All parties in this case are free to disconnect at this time.
Your Honor, I had one question, just administratively. Because there were two separate motions, do you want two separate orders or do you want one order addressing both issues?
I think you can put it in the same document. I think that would be fine.
Thank you.
All right, thank you.
Thank you, Your Honor.